Good afternoon, everyone. Welcome
Good
to another
afternoon.
exciting. Good afternoon. Welcome to another exciting edition of the ESK Practical Lawyer webinar series. My name is Jessica Ikinedu. I'm the moderator for today's webinar. At ESQ Training Limited, we provide comprehensive continuous professional learning with courses and training across various areas of practices. We have tagged this webinar series to launch our webinar series as slated to hold at 3 p.m. every Tuesdays and Thursdays respectively. After every section, we'll provide the resources in easy accessible format on a go for everyone who is interested. And today's topic is employment law issues for in-house lawyers. And some of the things that will be discussed today are wage underpayment and changes in modern award, as well as strategies to reduce the risks. Then the role of corporate counsel in preventing and responding to workplace bullying, harassment and discrimination, as well as emerging issues. If you do have any question while the webinar is going on, please do type in the Q&A or raise up your hand, and in due time it will be answered. It is with great pleasure I introduce our speakers for today. We have Mr. Kelly, who is the Managing Associate at Aloko and Oyobode, and we have Mr. Akolade, who is a trustee at the Employment and Labor Lawyer Association of Nigeria. And our first speaker is Mr. Kelly. Over to you, sir.
All right. Good afternoon to everyone. Hello, Jessica, you can hear me, right?
Yes, I can.
Okay. So, as slightly mentioned, I'm going to look at the topic, the role of corporate counsel in preventing and responding to workplace bullying, harassment, and discrimination. I trust all of us are having a good day so far. I'm going to try to, I believe I can share my, I'm going to try to share my slides. Can you confirm that you can see, Jessica?
Yes, I can.
Okay, excellent. So as I mentioned, the role of corporate counsel in preventing and responding to workplace bullying, harassment, and discrimination. We'll try and take it as quick as we can. It's the middle of the day. Probably some of us want to get back to some other things. So we'll go to the first slide, and I ask the question as an introduction. Who has heard of, you can answer by responding in the chat box, but who has heard of Rory O'More or any other person named Samuel Lover? If you have, just drop your answer in the chat box. Let me see if somebody has heard of these two personalities before. They are historical figures, but we'll get to understand their connection to this subject as we proceed. Anyone? You can just drop it in the chat box. I give them 30 seconds. There is no answer, and then I expect that nobody has heard of these two names. All right, no response, so I proceed. Then I'll show you who these two guys are in the course of the presentation. The outline for the presentation and this subject is set out on your screen. I'll look at the face of the workplace, bullying, harassment, discrimination, and then the response of corporate counsel or in-house counsel. Should it be proactive or reactive? Now, on the face of workplace, then and now, most of us are aware of the traditional workplace model, which is in person, Large organizations operate branch offices. Yes, we know that, but typically with minimum integration. So it was essentially, you wake up in the morning, what you typically call the 9 to 5 routine. You get to a physical building, you work with your colleagues, you share office space. If you share office space, and at the close of work at 5, 4, 6, you are commuting back to work, back home. Now, a few organizations did allow for other flexible models depending on what they essentially do. We're aware of IT companies that have popped up. They don't necessarily require you to be physically in place in the office. You can work sometimes from wherever you are. But then that was pre-COVID, and very few companies really, gave the opportunity for flexible working. But then there were one or two that had provisions for remote or hybrid working. Now, COVID-19 brought rapid changes. All of us, it's something that happened very recently. All of us are aware. Very, very rapid changes that now you see employers offering flexible work models that offer a blend of in-office, remote, and mobile work. I already mentioned what in-office is. We know what remote working is as well. Hybrid is there, but mobile work is a bit different. This is where you can simply just, it's some form of remote working model, but you can work from wherever you are. So I can wake up, decide to go on a holiday or just travel to the UK, travel to Ghana. But in the course of all my travels, I'm still at work. I don't necessarily need to stay in Lagos. I don't necessarily need to stay in Port Harcourt, provided I do the work and I show up when I'm required to be at work. If their working hours are 9 to 5, nobody asks me where I am, provided I'm able to do the work. Mobile work, that's becoming quite common. Now, employees now do have more flexibility to get work done when and where they are most productive. So this means a lot of flexible schedules. We expect that the complaints about work-life balance will reduce to some extent. The hybrid work model that I mentioned earlier is becoming quite popular, especially with a growing millennial and Gen Z workforce that values flexibility. I would think that most of the people on this call are either in the millennial, in this session are either millennials or part of the Gen Z population, and they value flexibility a lot. So variations have been put in place that include hybrid at will. Some organizations just say, work how you want to work. If you want to come to the physical office, why not? Choose the days you want to come. Nobody is going to ask you when you are coming. If you want to work remotely, work remotely. If you don't want to ever come to the office, that's fine. But then it's entirely within your control. Others have slight variations. Let's say you are required to be in the office at least 2 times in a week or 3 times in a week, but does not. But the employer will not tell you when in these days in the week you should come to the office. So you choose when, whether you come on Tuesday and Wednesday or you come on Monday and Friday. And then there's the hybrid split week, where the employer clearly tells you when to come in, either on Monday or on Tuesday, or you're off on Friday, or you're on 1 week and you're off the next. And then we have the hybrid manager scheduling. This is similar to the model I just explained. The employer clearly schedules when certain persons will be in the office. Especially with COVID-19 protocols about social distancing, the need for every building to have only 50% of its capacity occupied at the time, a public building or office space to be occupied by only 50% of the occupants. So you find that managers typically do the scheduling so that 1/2 is in the office or less than that, and then it rotates in that manner. And then you have a hybrid mix. The hybrid mix is a mix of any of these models that I've just referred to. So we are really in interesting times. Now, what a workplace should be in the present. Some of the things I've highlighted here have always featured in the workplace, but then there have always been issues as to whether they are available or they are not. So a workplace, as we know it, should be healthy, as it should ensure that the emotional and physical safety of employees is guaranteed. It should be diverse and inclusive. So you are expected to have people from different places and backgrounds being given the opportunity to work in an environment, especially large corporations. Of course, we can't say the same for small scale businesses to some extent, but for corporate and in-house counsel who work in structured organizations, your workplace should be diverse and it should be inclusive. There should be no discrimination on any basis. Now, the workplace should also operate based on mutual respect. This respect should be both vertical and lateral, from superiors to subordinates and vice versa, from colleagues to colleagues and vice versa. So, you as in-house counsel or in-house counsel who are on this in this session, you need to ensure that the workplace operates based on this principle. There must be mutual respect. Now, it must also be free of bias, prejudice, and harassment. And bias is similar to the item about inclusiveness. There should be no prejudice, and also there should be no harassment, as we'll come to see. Now, I'll look at the specific components, which is bullying. I'll start with bullying. Most of us have a fair idea of what bullying entails, but I'm going to go through it quickly. Bullying includes intimidating, malicious, or insulting behavior towards a colleague, whether superior, subordinate, or intermediate colleague. It often involves abuse or misuse of power and is intended to undermine, frighten, humiliate, denigrate, injure, or cause harm to the recipient in some way. It is generally of an ongoing, pervasive nature, but might also be a single incident. Of course, it may be subtle, it may be in person, it may be by phone, maybe by email, or through social media or other electronic communication. For example, verbal aggressions such as shouting or swearing, persistent, excessive, unwarranted, or unfair criticism. I'm sure some of us can relate to some of these points. And public humiliation, ridicule, taunting, or unwanted. Could also be constant ignoring of opinions or repeated intentional exclusion. The spreading of dishonest and or destructive rumors about a team member or the agency, this case may be threats of or actual physical assault, intimidating someone who has filed a complaint or is considering filing a complaint. All this would constitute some form of bullying. Now, harassment. Harassment is behavior. Of course, it's also physical or verbal that demeans, humiliates, or embarrasses a person. It can cause emotional or mental suffering, certainly, and it can come in the form of slurs, insults, or other threatening behavior. When it can be physically abusive, threatening, or intimidating behavior. It can be one that creates an atmosphere of tension or oppression, one that makes it can be the making of derogatory or offensive remarks, and it can be sexual. And when it is sexual, it qualifies as sexual harassment when it is an unwanted, unpleasant, offensive, or threatening conduct of a sexual nature, but must be distinguished from sexual attention that is welcome and mutual. Now, this is something I picked from Order 1, Rule 10 of the National Industrial Court rules. Specific provisions are made about sexual harassment and discrimination in the rules. And in the definition of sexual harassment, it tries to make that distinction between unwanted and unwelcome advances and welcome and mutual advances. Sexual harassment can be non-verbal, we've already noted that, and it can be quid pro quo. Yeah, this was supposed to be quid pro quo. Just for better context, quid pro quo relates to situations where typically a subordinate is expected to give something to a superior in exchange for some favor, either favor or advancement. It could be for the purpose of employment, promotion, bonuses, privileges, and if what is demanded of the employee or the subordinate is sexual in nature, then it qualifies as sexual harassment already. Now, discrimination. It is any negative action or attitude that is directed towards someone because of his or her membership in or affiliation with a particular group on the basis of age, disability, or medical history, ethnicity, national origin, race, caste, or socioeconomic status, religion, gender, family status, marital status, etc. Now, the unfair or unequal treatment of an individual or group in hiring, assignment, execution of duties, training or development, promotion, or any other facet of their employment based on any of the characteristics described above will also qualify as discrimination. Now, what should be the response of in-house counsel? Should it be proactive? And if so, what should it entail? Now, in-house counsel in the discharge of their duties, remember, they are very essential, a very essential aspect of any organization, because they guide the policies and compliance with regulations and laws for every organization. So they need to be out there in the center of things. Now, should they be proactive in their response to workplace harassment, discrimination, and bullying? Well, we'll get to see that. In proactive, in-house counsel need to develop policies around bullying, harassment, and discrimination. A good guide is the International Labour Organization Violence and Harassment Convention number 190. Sometimes it is just called ILO C190. This was adopted in June 2019, but unfortunately only 10 countries have ratified it so far. Nigeria, not yet. Let's remember as well that by the Constitution of the Federal Republic of Nigeria, the mere ratification of a treaty does not make it law. It must be domesticated. But at the same time, the National Industrial Code Act allows the application of international treaties and best practices in a determination of matters brought before that court. So, well, that appears to be some exception because it's contained also in the Constitution, allowing them to do that. Now, if a policy around these issues has been set in place, there is the need for in-house counsel to ensure that these policies are reviewed and updated periodically, because there are always changes in policies, government policies, changes in realities, current realities. Like I referred to COVID-19 and its effect to the workplace in the present. Now, maybe a couple of 5 years ago, in-house counsel never envisaged that they will be talking about other forms of other work models, whether hybrid, flexible, or totally virtual arrangements. But now these things are beginning to come up. Those who work in the fintech space may likely have situations where some people have been employed entirely virtually. The whole process went virtually. Appraisals were done virtually or remotely. And even at the point these employees left or resigned from their employment or were asked to leave, it was also done virtually. Probably no physical interaction at all throughout the period of the employment. So with policy changes, there's a need for in-house counsel to also set specific time, periodic timelines for review and updating policies that they may have put in place. Now, these policies should, as of necessity, cover reporting procedures. Now, if a policy is in place, and it merely says this is what constitutes unwanted behavior, harassment, bullying, or discrimination, but says nothing about the victims of these acts and how they would seek redress internally, then that would be an incomplete policy. So there should be a clear reporting process. Who do you go to? As you would see below, where I mentioned reporting channels, who do you go to? Do you go to one person? Do you go to more than one person? What if the person that is subject of the complaint is one's direct superior? Should that be an appropriate channel? Should there be alternative reporting channels? These are very, very important points to note when coming up with these policies. And if the policy exists and does not cover this, then it is important that it is reviewed to allow a safe working environment for every employee. I mentioned earlier about bullying, where somebody is even victimized for complaining. So the appropriate or the advisable standard should be, that there's a clear reporting channel and it should be multiple. Then we have disciplinary actions. They should also clearly set out what the disciplinary actions will be, what will be done if in the event where somebody violates the policy and it becomes the subject of a complaint. There should be periodic trainings for staff members as well, for all cadre, both seniors, juniors, junior cadre. Everybody should go through this training and understand what is acceptable and what is not acceptable. Policy should cover that as well. Now, in-house counsel must always be available to the decision makers in their organizations. This is to promote informed employment decisions. Now, if you are detached and you are only showing up when there is a legal matter to resolve, then it won't be as helpful to your organization as it should be. So it should be available. I know some in-house counsel are available at board meetings where they make suggestions, but then they should be at the core with some synergy with the human resources departments of this organization. Some of them call these departments people and culture, but by whatever name it is called, there should be some synergy between in-house counsel and the people that make the decisions. Now on still being proactive, I mentioned litigation earlier, but in-house counsel shouldn't just show up when there's a legal issue to resolve. Now, when these steps are taken, they of course will prevent avoidable litigation, both civil and criminal. Now, there are offenses that are created under penal laws, like the penal code of some states in the north, the criminal code in the south, Violence Against Persons Prohibition Act in the case of the FCT, or the law in the case of some states who have enacted similar laws. The thing here is, by putting in place processes that avoid the occurrence of these events, in-house counsel are able to save the organizations. They need less response to processes in court. It can even, for even criminal charges, the company may be deemed to be to have colluded or created an environment that allowed that kind of practice to thrive. And so you may just be needlessly made a party. And before you are able to argue your way out of it, reasonable time and expense will have been incurred. Now, should it be reactive? We've looked at proactive. Should it be reactive? Now, being reactive means coming after something has already happened. But then it could also be reactive in spite of policies being on ground. Somebody may violate it from time to time. So respond appropriately when anything happens. That will set the tone for everybody to know that these actions are not allowed and they are not acceptable. Make sure that there's proper investigation so that there's closure whenever an issue comes up. Make sure that actions are taken promptly and appropriately as well. So you don't kill a fly with a hammer, neither do you pat a horse with a fly whisk as a punishment. Now, use incidents to open communication with staff members. This should be preached to HR and to those who deal with staff members directly. When an incident happens, it should form the basis for further communicating with people as to what is right and what is wrong, what is allowable and what is not allowable. Now, in-house counsel also need to ensure that the organizations are decisive regardless of the status of the persons involved. So it cannot be because it's a manager or whatever, actions will not be taken, the policy will be violated, or the company will turn a blind eye. Now, in-house counsel also need to ensure that they avoid conflicts of interest. So they should play a very central role, neutral in some sense, so that they are not in the midst of it, having advised on what should be done and then being actively involved. This is similar to the principles of law, or the altruism pattern. You cannot be a judge in your own case. You cannot be the person advising certain of the policies and also insisting that you are part of the disciplinary committee that may be set up for disciplinary actions. Now, don't wait till you get to court. Don't wait till you get to court. There are policies, these policies can have embedded in them processes that would ensure that whenever anything happens, it would be quickly resolved. The NICN rules, for example, envisages that these issues happen in the workplace, and so has a whole order, a substantial part of an order, Order 14, providing for sexual harassment and workplace discrimination. And as most of us will know, the NICN has shown over time to be an employee-friendly court. So the employee is seen as the weaker party, and is likely to be seen more favorably first before the employer is able to prove otherwise. So it's important to not wait till a matter gets to court. Now, a company, for example, in issues relating to waiting to get to court, there was a case of Maduka and Microsoft, where the company was held liable for the harassment of a staff by a person who was in a superior position because the company failed to follow its harassment policy, and the failure amounted to a ratification of the conduct of the area employee. So this is where there's even a policy on ground. Yet, because the company did not see through it, it also became liable for the conduct of its employee. So it's important that even, like I said, even after the policies have been set, be proactive enough to ensure that everything is followed to the letter and avoid a needless recourse to court. In another case, Akin Shetty and Western Gelco Seismic Nigeria Limited, the company was held liable for doing nothing, even after the case of harassment was reported to its human resources. Now, if in-house counsel are in tune with these departments, like I mentioned earlier, then these matters will not be left like that and then end up being in courts and then expose the company to liabilities, sometimes very huge. Victims may also resort to criminal prosecution. I mentioned that earlier. And we know the principles of criminal liability. There must be mens rea and there must be actus reus. But then, who says that the company may not be joined as a participes criminis, either as an abettor or a co-conspirator? All these are possible. So it is important to, even being reactive, note that there is enough basis to avoid being reactive by being proactive. And this takes me to my last slide, which relates to the first slide, where I mentioned Samuel Lover and Rory Omo. So those who didn't know, the final word for this session for the moment is to be better safe than sorry. Put differently, in-house counsel need to be more proactive than reactive. Now, this saying was the earliest known use of this saying or this proverb was by an Irish songwriter and novelist, and that's the person called Samuel Lover. Lived in 1797 to 1868, and he used that phrase or saying in his book, Rory Omo, A National Romance. Rory Omo was an Irish historical figure, and that book was a part love tale and a part social commentary. That's the end of the presentation for now, and thank you for listening. Subject to any questions that may be asked for clarification. Thank you. Jessica, over to you.
Okay, thank you so much, sir. Our next speaker is Mr. Jamiu Over to you, Mr. Jamil. And please, if you do have any question, you can type on the Q&A. And after Mr. Jamil's presentation, the questions will be taken.
Thank you, Jessica. I'll just try to walk my slides. Hopefully you can see it. I know I struggled with the video. Can you see my screen?
Yes, I can.
Great. Good afternoon, everyone, and thank you, Dendam, for giving us a riddle no one was able to solve. A nice presentation anyway. So, good afternoon, everyone, and thank you for taking time off your busy schedule to attend this lunchtime webinar. I'll be speaking on liability for underpayment of wages. And let me say something about this topic. When I was contacted to do this webinar, you probably would notice that my topic is different from what you have on the promotional materials. So I saw Jessica, what's it again? Modern award and wage underpayment and changes in modern award. And I had to quickly message Ogadere Fashola to say, this topic you're giving me, I don't think I know anything about it. What is it about? And he said, oh, modern awards, he gave the definition. So it then turns out, as I found out that this, I think it was, I won't call it an error. Someone put together, just went on the internet and put together a topic. But when you talk about modern awards, it's not a concept that exists in Nigerian law. So the idea of modern award is unique to the Australian labor law system. And basically it means a special document or legislation that provides for minimum standards in terms of work conditions outside of the general labor law structure. So for instance, in our case, you have the Labor Act, but then having some other regulation regarding pay and other work conditions. They call it a modern award in Australia, and it exists for virtually every sector. So the oil and gas sector will have their own modern award, hospitality sector, and all of that. So I was then quite comforted that I wasn't as ignorant as I thought I was when they gave me a topic. I thought with all my years of labor law experience, I couldn't answer. So what I then did is to weave that topic into what suits our environment that actually exists in Nigerian law. So we do have some form of legislations, guidelines, other frameworks different from the minimum labor standards that regulate pay. And that's what I'll be speaking to. And of course, looking at the role of in-house counsel and generally lawyers in dealing with some of these issues. Now, what is a wage? We see that even in the Holy Bible, it says a laborer is deserving of his wages. That shows you how critical the issue of wages is. And the exegesis I've read of this verse in terms of the meaning is that a laborer should be paid as soon as he has done the work. If someone doesn't do the work and then you are posting him now and then, owing him money, the Bible doesn't support it, and Nigerian law doesn't support it. So I put together a short roadmap of what I want to discuss this afternoon, because it's quite a very narrow area of labor law, but they're quite exhaustive if you want to really dig deep into it. So we'll look at the sources of wage regulation in Nigeria, what the consequences for underpaying wages could be. And then We'll also look at the means of resolving wage disputes, and of course, role of in-house counsel in resolving all of this. So what is a wage? A wage, I mean, it's simple enough, is money you'll be paid for your labor or services based on a contract that you've signed, or even if you don't have a contract, by the minimum standards expected in your industry or by legislation and all of that. And we'll see all of that in a bit, because of course, I'm sure the people on this call have the minimum understanding that a contract doesn't need to be in writing according to the Labor Act. But what we'll see in the Labor Act is that there's actually enough provisions protecting workers' wages. And one thing that I found interesting when researching this topic is that, people, especially in this part of the world, we try to downplay money. You talk too much about money, they say you like money too much. But Section 1 of the Labor Act actually is on wages. Before it even went into what is a contract and everything, first talked about money. That shows you how important this topic is. So in Section 1 of the Labor Act, we see extensive provisions on protection of wages. And what does it say? It prohibits a number of things. You cannot choose to pay your worker with a handshake and say, oh, and I hope there's no senior counsel here. I'm training you, so the training you are receiving here is enough payment for your work. So you don't expect any money. That is actually prohibited. So you cannot agree to or purport to pay someone, a worker, by any means other than legal tender. Just give him his money and let him go his way, and don't offer him any other things in payment. And then you cannot dictate to a worker how he is to spend his money, really. I haven't seen that happen in the course of my career, but I can imagine that maybe some, I don't know, but you can't dictate how a worker should spend his salary. You cannot also give advance of wages, more than 1 month's wages, to a worker. So yes, there's pressure of money all the time. Then the worker says, please, can you give me like 6 months of my salary? I will not ask for money again. Just let me be working. Just give me my 6 months. Let me be working until I finish that money. That is not allowed. You can only give an advance of 1 month. And you can also not deduct more than 1/3 of monthly salary for deduction. So maybe a worker has taken a loan and you're deducting the money. You cannot deduct the whole of the loan at once if it turns out to be more than 1/3 of his salary. And for those of you who are familiar with, who are experts in taking loans from banks, you see that this same calculation also goes into taking of loans. They work out what is 1/3 of your salary. And if your monthly repayment exceeds that sum, then you can't afford that loan. That's what it means. But what is permitted that you can deduct as an employer? You can deduct if an employee has caused loss to you, maybe out of negligence. Your worker is a banker, is a teller in the bank, and someone signs a withdrawal form for 10,000. He ends up transferring 1 million naira to his account. That is a loss arising from negligence. Of course, you're also allowed to deduct monies based on the agreement of the employee or the worker for things like pension contributions, union dues, cooperative, isusu, and all of those things. But all of them based on the consent of the employee, right? And there's one important point that this section actually says, that even in cases where you overpay your worker, so you've been paying someone 50,000 instead of 45,000 for the past 6 months, and you suddenly discover that at the 7th month, oh, there was an error in the payroll, we're paying this person 5K above his salary. You cannot deduct more than the 3 months preceding that period when you discover. And there's a reason for that. But what you see here is that there's a lot of protection for wages. That's the Labor Act, right? But apart from this, you have so many other sources of law when it comes to regulation of wages. The Labor Act, of course, is a statute, but the more specific statute when we're talking about wage regulation would be your National Minimum Wage Act, which currently fixes the minimum wage for Nigeria at 30,000 naira, which will be renewed or looked into again, reviewed after 5 years. That also puts a penalty for employers who pay below the minimum wage. But we'll get, to that in a bit. Of course, we know not everybody is paying that minimum wage. But in terms of exceptions, the Minimum Wage Act applies only to employers who have 25 employees and above. And then it also excludes people who are engaged in part-time work, people who are in seasonal employment. For the Yorubas, we call them alagbaru. So someone is just a farm hand that you call on during the farming season, and he says he wants to be collecting minimum wage every month, 30,000. It won't work. You get paid when there's work to do. You get called when there's work to do, and you get paid according to the work. So the Act recognizes all of those and has all those exceptions. Then Pension Reforms Act also regulates wages in some form. And perhaps what I should have said from the beginning is that when I talk about use the word wage, I use it in an all-embracing sense to include wages and salaries and all other emoluments. But of course, strictly speaking, wage would be payable per day or per hour or weekly, while salary is payable monthly. But in this sense, I'm looking at it from a broad perspective. So that's why you see the Pension Reforms Act on this slide. And what does the Pension Reforms Act have to do with wages? Of course, there are statutory deductions that employers are allowed to make from employees' emoluments for the purpose of pension, added to the employee's own contribution, and it is paid into the retirement savings account. That money in the retirement savings account is for the benefit of the employee, and so it forms part of his remuneration. And of course, we have all other, every other statute that deals or regulates pay in some form. Then contractual terms, that's simple enough. You sign a contract, it says this is your salary, this is your bonus, this is your allowance, it will be payable every month. These are the deductions we will make for health insurance and all of that, so that it is clear. But now, the part of our jurisprudence that seems similar to the modern award that you have in Australia, if you ask me, would be this collective bargaining agreement. Now, a collective bargaining agreement operates in a unionized environment. So in sectors where you have unions and that union is active, what will usually happen is that regardless of the individual contracts that the employee or the worker has signed with the company, the union will sit down, usually every year, and discuss with the management. You have to review this pay. The dollar is going up. Can you increase salary by this percentage? Can you give us cost of living allowance? Can you convert our allowance to dollars to hedge against inflation? Can you reduce our working hours and all of that? So the union, on behalf of the employees, actually have themselves in a position where they are renegotiating contracts on behalf of their members. And when these negotiations come to fruition, you then have a collective bargaining agreement that is prepared and which then regulates the pay of every worker who is a member of that union. So in a sense, that collective bargaining agreement itself becomes a legal framework or a contractual framework over and above the individual contracts you sign. And that's why I say similar to the minimum modern award system that you have in Australia and I think New Zealand. And then you have industry guidelines and regulations too. As lawyers, you remember that recently, even the NBA tried to do something. A committee set up by the outgone administration prepared a report on minimum salaries for lawyers based on different locations in Nigeria. And I think it's still a recommendation for now. But if it does become a regulation, I can't say law in the strict sense of it, then it will fall into the category of this kind of frameworks we're looking at, where you have sector or industry specific document regarding pay and all of that. Another good example is in the maritime industry. Seafarers actually have this enhanced payment structure, which is transnational. So the ILO has a convention on the welfare of seafarers. And just this year, they fixed the minimum wage of seafarers. Seafarers meaning people who work on ships at $658 per month minimum. And then of course it increases year to year. They fixed it up to 2024, I think. So all of this together are other sources of wage regulation, just to point out, I mean, just showing that your wage is not affected only by what you signed on paper. It also could be affected by many other things. But despite all of this enhanced, extensive frameworks that we've talked about, why then do we have underpayment of wages? The honest truth is that most times it's based on ignorance of the people in charge. Here I'm talking about the HR practitioners. Of course, in-house counsel will blame HR before they blame themselves. So let me blame HR first before I blame the legal department. Sometimes, especially these days, the labor law jurisprudence is developing fast. Regulations are being churned out every day. Just last week or 2 weeks ago, the Pensions Commission came out with revised regulation for processing of death benefit, retirement benefits. If you're not the kind of person, in-house HR person or lawyer that keeps up to date with this thing, you probably won't know. And you're calculating benefits for someone and you're using the old guidelines, automatically you short paid that person. And that's how easy it is to fall into non-compliance. But sometimes it's also deliberate. So your contract guarantees you 50,000 naira per month. And then you come to work one day, you forgot to go and greet the oga as other people are doing before going home. Say, you, this boy, you are very rude. Remove 10,000 naira from your salary. And just like that, I'm sure some people are laughing, but that happens a lot in this client. Did you take permission before leaving yesterday? Remove 500 naira. Who put on the generator when I'm not in the office? Remove 5,000. And all these deductions not supported by law on the contract. Some will negotiate, pay with you 50,000, and after paying for 2 months, the next third month you start seeing 10,000, money trickling into your account like a pipe-borne water that has lost connection to the tank, and you are wondering what's happening, and you say, don't you know that there's no market? Paying lesser wages than what has been contracted. And of course, when you don't comply, and this is very rampant, many companies, employers they either don't deduct at all, or they deduct for pensions and tax, and they do not remit. So they've been deducting your money for pension, and after working for 5-7 years, you leave the company, and then you check your RSA, and there's nothing in it. All of these are forms of underpayment, and they are either based on error in calculation, misunderstanding the applicable law. And in the case of the public sector, the National Assembly has passed a law on minimum wage, the National Minimum Wage Act, and the states are looking at them, the federal government with one kind eye, say, okay, you have fixed the money, oh yeah, come and pay it now. So what you find out is that in Nigeria, the minimum wage is 30,000, but not all the states are paying 30,000. Some states are not paying at all. Some states are paying 10,000, 12,000 as minimum wage. And they're basically saying we cannot afford it. So that's a political issue. It's a political issue that is best solved in the political process, right? So That's said about why they are on the payment of wages. But all of this is not without consequence, of course. If you're being paid, or if you're paying someone less than what was contracted with that person, if it has to do with pension, for instance, a petition could be written to the industry regulator, PENCOM, or sector-specific regulators. Maybe it's an insurance company, they could write to NICOM, and even CAC has investigative powers. They could investigate the company and find out if it is a pattern and why they are not paying. And of course, you know that under the Pension Reforms Act, for instance, there is a penalty for pension that you failed to remit at the time you remit it. You know, and all of this really affects your reputation in public. You do not want to be seen as a company that does not pay its people or owes salary or is cheating its workers of its salary. It could also lead to business disruption, especially if the union decides to take up the issue and they are blockading, picketing your premises and all of that. But how do you resolve it? Dendam has, summarized this beautifully in terms of you do not have to wait for litigation. And that is why you see litigation at the bottom of my list. Usually, once you discover on your own that you've been underpaying people, maybe take a CBA, for instance, it's a collective bargaining agreement. It says it applies to all employees on social level or whatever, but sometimes there might be a misunderstanding of which workers fall under which cadre, for instance. So you are probably applying the rates for junior employees for a senior staff, or you are overpaying junior staff by giving them more gas salary. So this can happen. But what you do when you discover is to do a good audit and get, engage the union or engage the employees to say this has happened. We're looking at it and, do what is right. So engage people, do your ADR. If it's a union issue you're unable to resolve, it will lead to a trade dispute. And under the Trade Disputes Act and the mechanisms stated there, the ministry could help you resolve it, or you resolve it amongst yourself using labor dispute resolution processes. Hopefully you won't end up like ASU and the federal government. And then of course, if all of this fail, litigation might be your last resort. But if you're in the wrong, you actually don't want to get to that level. What is the role of in-house counsel? Speaking specifically now, your number one, the best skill you should have as a lawyer, let's even forget in-house counsel or outside counsel, is the skill of staying up to date. And this can't be emphasized enough. A lawyer needs to be up to date in the area of law practices in the sector he operates in. You should not be the last to know. When the MD even knows about development, before you, the lawyer, they begin to wonder why they are paying you. You don't want to be in that situation. You want to be in the position where you are the one telling, MD, have you heard about this new regulation? I think it's going to affect our payroll. We should look at it. We should do a review and say, yes, this is why we employ this person. So you need to be able to review all your statutes, your contracts, the CBAs you've signed with unions to understand what your obligations are. When are they due? Are they being paid as at when due? Are there any ambiguities in there that you need to clear? And then you need to compare and assess your level of compliance. If there are any gray areas or ambiguities or areas of non-compliance, you should actually be at the forefront of throwing this up and making sure that they're addressed. So you don't know, for instance, that you're meant to be deducting for ITF, or you are not meant to be deducting ITF because you do not meet the threshold or the minimum number of employees to fall under that scheme. Those are the things you should be looking at and rectifying. And then once you do all of that, you should be a compliance champion by advising the company on what needs to be done. Basically saying we need to comply and this is how to comply. And while you're doing that, if you, again, repeating what I said in the previous slide, when you've decided or determined that there's something wrong that you need to redress, the best bet or course of action is to engage the individual employees, engage the union, show good faith, build trust, to show that this was not deliberate, we're looking into it, we need your cooperation to resolve it. And most times you find that the worker side is also very cooperative and understanding if they see or sense good faith. So I believe that's the end of my presentation. Thank you for listening, and I'll be happy to take any questions.
Okay, thank you so much, sir. Okay, I think we have one question. The person said, you mentioned a pension account. Does the law require employers to open a separate account for that purpose?
Sorry, could you repeat the question? Hello?
Okay, the person was, I can hear you. The person said, you mentioned, can you hear me?
Yes, please. I was looking for the question myself. Not sure I can see. Please go on.
Q&A. So the
Okay.
person said you mentioned a pension account. Does the law require employers to open a separate account for that purpose?
Oh, okay. Require employers to open a separate account for that purpose? No. What the law says is that the employee, the worker, should open a retirement savings account with a pension funds administrator. So the account that needs to be opened is called a retirement savings account. And you have companies whose job is to manage pensions. They are called pension funds administrators. Without meaning to advertise for any company, I'm sure you've heard of companies like Stanbic, IBTC Pensions, ARM Pensions, First Guarantee Pensions Limited, and all of that. So you open the account as a worker with those PFAs and you notify your employer. What the employer then does every month is to make the statutory deductions, 10% contributions by the employer, then 8% deduction from your salary, and the 18% is put in that retirement savings account every month. The employer doesn't have any control over that account. When you meet the threshold, when you worked out for many years and you reach your retirement age, then the PFA starts paying you your monthly pension due after paying your lump sum. That's the answer.
Thank you, sir. Someone is asking, from my research, I understand the definition of a worker working under the Labor Act is limited in scope. Does this imply to non-workers? Does that imply that non-workers are guided by these various contracts of employment?
Okay, I guess this is still for me, right? You want me to answer this?
Yes, sir.
Okay. So, yes, the definition of worker is limited to people in administrative, clerical work and all of that. And you see, I hesitate in answering this question because there are two schools of thought. If you ask me for my personal position, which is also backed by case law, of course, you'll find other case law that say the opposite. Every worker in Nigeria is regulated by the Labor Act. The reason why that is so is that apart from the Labor Act and other acts that now speak to specific issues, there is no other general law regarding labor in Nigeria. It is the Labor Act. So when the Labor Act says in Section 91 that a worker means someone in administrative, clerical, manual works, does it then mean that every other person, the labor doesn't apply to them? I mean, that's what you're also asking. That cannot be so, because almost all the principles that we have in the labor law jurisprudence derive from the Labor Act. And a common example I always like to give is with maternity protection. So a woman is pregnant and you then say, you cannot go on maternity leave because you are a senior manager. The Labor Act does not apply to you. Yet it is sections 51 or 57 of the Labor Act that provides for maternity protection. Does it then mean that a woman who is not a worker is not entitled to maternity leave? You will not there go and say that before an NIC judge. And I can't remember the case, but I think it was the president of the court in a case who said the Labor Act actually is the standard, minimum labor standards for Nigeria. So despite that restrictive definition in Section 91, the answer is every employee is regulated by the Labor Act. What then happens when you have a specific contract is that you can then agree between you and your employer specifics of issues that are either not provided for in the Labor Act or to provide more for it. So for instance, the Labor Act has nothing on confidentiality or data protection or I mean, things like that, sexual harassment. Your contract of employment would speak to that. Then there are other issues that just say, oh, you're entitled to leave not less than 6 days for sick leave. You can have your own contract, which would actually give you sick leave of up to 3 months or even up to 1 year, as most multinationals have. So I'm not sure if that answers your question.
Okay, thank you so much. Mr. Kelly, would you like to say something to that?
Jessica, no, I think he's covered the subject. I would just want to ask Jamie, I think he referred to a decision of the industrial court. I don't know whether it's something he has handy and could be typed into the chat so that especially the person who asks the question can have the benefit of reviewing it as well. Yeah.
Oh, you mean on this issue of application of the Labor Act?
Yes.
Okay, I will get that and probably share with the Esquire team later.
All right, I think there's a follow-up question, and I think I'm sure you can take that, Jamie. All right.
Well, yeah. So I mean, I'm not surprised there's a follow-up question. This is it's a hot topic. It's very debatable. For cases on the other side, saying that if you are not a worker, it doesn't apply to you. I remember offhand the case of Evans and Falaye, an old case, and then you have a few others too. I'll get those authorities. But in terms of conflict, now this is an interesting question because we all know as lawyers, for instance, that you cannot contract an illegality. I don't know if I'm putting it the right way. So if you have a contract that says you cannot go on maternity leave or you shall only get pregnant once every 4 years, that is clearly illegal. So if you have a contract of employment and it provides for enhanced benefits over and above what's in the Labor Act, yes, your contract will have precedence because you are providing enhanced benefits. But if your contract then seeks to bypass or circumvent or give you less than the minimum you're entitled to under the Labor Act or other laws, then it becomes a problem because you're not contracting against public policy. So the answer is your contract of employment only takes precedence if it gives enhanced benefits and not otherwise. I hope that helps.
Yeah, and to add to that, I recall saying something in the course of my presentation about the industrial court being allowed to apply international best practices in giving its decisions. So the likelihood of the courts refusing to, of the court agreeing with a practice that contradicts provisions of the Labor Act it's very minimal. Because like you said, if there are minimum standards, they are for junior cadre staff. Let me just use that expression. And if a junior cadre staff can be entitled to such privileges, what more of a senior staff? Yeah. So based on those principles alone, it's likely that when it comes for interpretation, the court would lean more towards the minimum standards than the other standards that you provided in your employment contract.
Yeah, I agree. I was going to say something about your presentation on harassment and bullying in the workplace. And if you follow me on LinkedIn, you will see a post I made maybe I think last week or 2 weeks ago regarding a decision of the NIC in March. And it had to do with this topic that you just educated us on. And the case was Check Uadrago versus Uber Technologies. So for those who watch Game of Thrones, the warrior barbarian king there, Drogo, somehow someone found it funny that the employee's name sounded similar to Drogo and was calling him Drogo at work. And that person happened to be his supervisor or manager. So she was always making fun of me, calling me Drogo. And the man was, I don't like Drogo. I'm not the warrior. Why are you calling me Drogo? But eventually, I mean, they had other issues. So it was more, it wasn't clear from the judgment whether it was as a joke or as a kind of insult or whatever, because they were then having other issues regarding work performance and all of that thing. At the end of the day, they couldn't get along. The man escalated the issues to management, typical of employers, or most employers. Instead of tackling the issue headlong, they decided to say, go and manage your boss. And of course, they didn't stop. Eventually, the man was terminated and they sued. And they got judgment against Uber and the manager. And just like you said, with regards to that Microsoft case, in this case too, the court awarded damages against Uber because it refused or failed to address that grievance. And I think it's good we're having this kind of decisions so that companies realize that they cannot have a hands-off approach to issues of violence and harassment in the workplace. It's not going to be just the problem of the actual harasser. It's going to drag the company down with it, with all the reputational issues that follow when you allow these issues to fester. And if you look at that violence and harassment convention that Dindam referred to, it actually places specific obligations on the employer. It says, number one, you must have a workplace policy. You must implement that policy. You must train your employees on that policy. Know exactly, train them on the kind of actions, behaviors that are permitted and what is not permitted. And then finally, you need to have a grievance mechanism that gives people room or an avenue to lodge a complaint, pursue it, and you must be seen to take genuine actions to address those grievances. If you cannot show that you did all of this and there's a suit, you'll be jointly and severally liable with the principal harasser. I just thought to also add that on the back of your beautiful presentation.
Thank you, Jamie.
Thank you so much, sir. It has been a profound section today. I want to say a very big thank you to our speakers for joining us today despite our busy schedule, and looking forward to having your subsequent webinar. A very big thank you to our sponsors, African Law Practice, Alliance Law Practice, the New Practice, and DOA. And also thank you to our attendees for participating in today's webinar. Do enjoy the rest of the day. Thank you.
Thank you.
Bye-bye.
Thank you.
All right, thank you. Bye.
Have a good evening, everyone. Bye.